This is Sandip Chandarana talking. I'm the director of PUA. For those of you who don't know, PUA is the managing general agency for Arch Insurance Company. And this is a value-added service that we offer to our clients and to our agents out there. David Erickson is a valued partner of ours. He defends some of our insureds, and he also provides some risk management services for us. And so this is one of those value-added services that we offer under the program. David is truly one of the best in the business. I'm really looking forward to this presentation. It's going to be engaging and should be fun and exciting on a really pertinent here. Pre-construction services, cure or curse. With that, I'm going to hand it back over to David. And again, David, appreciate you doing this webinar for us, and appreciate everything you do for our program.
Well, thank you, and good morning or good afternoon, everyone, depending on where you are. And the first acknowledgement here really is that we are at the leading edge of this issue. This is an issue, as we're going to go through it, is something that I am seeing coming through in a number of litigated claims. It's something that's going to come through as a part of claims, and it's going to be coming through as both an opportunity and a challenge for the professionals that are out there. As with most of the things that I do, I spend about half of my time litigating claims, trying to unravel the problems that are there. After that, I try to take those lessons learned and put them back into the other half of my practice, which is the risk management, the coordination, the solving of the problems before they ever take place. And that's what we're really about here today. I want to share some of the stories, share some of the lessons learned, but then also build a platform for going forward into the opportunity moment and into the challenges that come out of that opportunity moment. Whenever we move into a really new arena or something that has not been prevalent, then we get into these challenges because we have to redefine the scope. And there are many variations about what we have here. And so as a means of getting us into this, let's just get ourselves underway here. And this is a classic example of what we are dealing with here. This, for those of you who don't recognize this photo, this came out of the 2017 collapse of the pedestrian bridge under construction at Florida International University. There were about 10 fatalities coming out of this because people, unfortunately, were parked underneath this bridge in construction as it got going. And this has really been one of the leading issues that is out there and driving where we're going with respect to this topic, because you will see that one of the findings that came out of that was for the National Transportation Safety Board. They concluded that, quote, inadequate peer review was a major factor in the pedestrian bridge collapse. So here we had an independent, theoretically, peer review taking place of this project underway, yet it failed, yet it collapsed, and the National Transportation Safety Board called it out as an issue. So for issues of public projects, of safety and otherwise, obviously things like this, things like the collapse of the condominiums down in Florida, things like in my home city of San Francisco, the leaning Millennium Tower that is there leaning and causing all of those issues, have led to increased calls for peer review, particularly and most acutely at an engineering level. But as we'll talk about it, it's also going into other areas as well. So that's half of the equation that's driving it. The other half of the equation is how to save cost, how to save time, and how to save money. The Kentucky Transportation Cabinet looked at constructability reviews. That is where you get the contractors and the construction managers in early during design to do their constructability review, have their input, looking at costs, alternate materials. And they concluded that over time, those types of constructability reviews saved over 1.25% of the project budget on average. 1.25% over the course of a project has significant impacts. That can also have significant impacts on the standard of care for design professionals. And we're going to talk our way through some of those things. But we have these twin drivers right now that are really driving towards the increased use of pre-construction services. It is the safety factor and it is the cost factor. And both of those come to play. Now, it is a rock and a hard place moment for the design professional. On one hand, to have the external input the validation, to have the confidence that you're going forward with your design, with the concurrence of these other entities, these other parties, is incredibly valuable, incredibly important. We're going to get into why that could be so valuable. By the same token, all of a sudden you have moved from having autonomy and relative control over your design into the potential reality of too many cooks in the kitchen, too many moving targets, a lack of control over that process. Historically, we would have contrasted the design, bid, build process with the design, build process, in that we had, in the design, bid, build, we got to control our design, and then it became precarious when it went out to bid and out to the public and all of those sorts of things. Design, build was a little bit different. We've had variations on those themes, integrated project delivery, some of those things. What I would characterize you, and one way I would ask you to think about these pre-construction services is, on some level, they are what I call IPD light. They are an element of IPD, but without some of the contractual incentives, other things that go along with that. So I think it is a focused, targeted, and limited version of IPD that we have out there. So these are the drivers that are really taking us forward at this time. One note, just let me make this comment here. Please use the chat room, the Q&A. Sandip and I are really here for you. We want to be here to answer your questions. We want to take your input as we go through this. So this is really about you. It's also being recorded. If you ever need to go back and take a look at it, want to go back and share this with anybody else, and it will be available through PUA for future viewing by others as we go through all of this. So now, to get really kind of underway with where we're going, here's our agenda. We want to talk about these industry trends and these dynamics. We talked a little bit about them, but we want to talk about the mixed messaging, the different dynamics of it, what's going on and where we think it's going to go. With that, what I want to set you up for is an issue-wide model. And what we're trying to do here is, rather than giving you, well, do this if you're the peer reviewer, and do this if you're having somebody peer review, and do this if you've got a contractor doing cost reviews, and do this if you've got a constructability review. We're trying to establish an overall protocol, an overall process to work through, so that you know what the issues are, you can develop the checklist, and then they can be tailored to each one of those situations. Because we're going to talk about, there are so many variations on the theme here, that to have a checklist, a process, a protocol to go to as a reference point, we think is really valuable. Then we're going to play that forward, and we're going to play it forward into the two predominant sides of this model. The first one is the peer review, where there's going to be another design professional, if you're a design professional, taking a look at, investigating, and looking into what you have going on in your design. That's going to be for the designer of record. We also want to take a look at it from the perspective of that peer reviewer. Remember what we already looked at, the Florida International University bridge collapse. One of the major 3 contributing causes that they looked at in that particular session was the inadequate peer review. And so what does peer review mean? What are your obligations, and where are your exposures in it? So many people have thought that it's a free pass moment because your professional stamp is generally not going on it. That might not be the case, as we'll talk about in a few minutes. Then we're going to go to the other part of it, where we have the constructability review. That is where contractors, construction managers, cost estimators, building officials, public review agencies, others are getting involved more actively during the design phase of the project. As they get into that, what interface does that have? How does it impact the design? What additional burdens, costs, obligations does it pose on the design professionals? And what is really the project impact coming out of it? What you will see is, you'll see the headline material like we looked at from that Kentucky board that looked at things and said, you can save 1.25%. I've seen promises much higher than that, but they will see that sort of thing, and they will jump into this expecting to get something positive out of it, but not really understanding the process that's out there. They it's a ready, fire, aim moment in terms of how they get into all of that and how they manage that going forward. Let's talk about really where this hits us as design professionals and what we have here. And here I have two examples from the legal side of the world. As I said, I learned so much of what I bring to the contract and the risk management side from what goes wrong in the courtroom. Well, these are the ultimate moments. These are examples of two of the jury instructions, the standard jury instructions that we would have here in California. They're pretty much similar throughout the United States that we would have them. The one on the left is the standard of care clause. I know because you are devotees to PUA, because you do the Kent Holland reviews and all of that, that you're all incorporating a good standard of care clause into your agreements. This is the standard of care that would be read to a jury. And what it says is that the architect or engineer is negligent if the architect or engineer fails to use the skill and care that a reasonably careful architect and engineer would have used under similar circumstances. This is referred to as the standard of care. So that's the legal definitions. That's what a jury would be looking at if they went back into the courtroom. That's what a judge is going to be looking at that's out there. So it's that reasonably careful architect engineer, not the most careful, not the most zealous, and all of those sorts of things. And it is under similar circumstances. So we need to read that in context. For that reason, the peer review, the constructability review, has often been seen as a real gift or a moment of grace for the design professionals, because rather than doing our design and then hoping later on if something goes wrong that somebody out there in our industry will agree that, yeah, you did what we would have done, you did what we thought would have been reasonable, it moves it forward. And during the time that we're delivering our services, we have essentially that seal, that commitment, that stamp that says, yes, based on our review, our input into the industry, what you've done out there is reasonable, it's good, and it's out there. The problem is that people then sometimes think that that elevates it beyond what it really is. And we then want to look over at the one on the right. The first person who can tell me in the Q&A room that they've done the perfect set of plans and specifications, please let me know. Let me know what the project is. I want to visit it. Because the standard of care, as would be read to a jury again, is that it is not perfection. It's not a warranty. It's not a guarantee. In California, a jury would be told an architect or engineer is not necessarily negligent just because their efforts were unsuccessful or they made an error that was reasonable under the circumstances. That was reasonable under the circumstances. And so that's what we're looking at in terms of the standard that's out there. It is not a standard of care of perfection. But what sometimes gets confused or lost in all of this is how a peer review, a constructability review, and otherwise impacts that. On one level, we want to say, if you reviewed it, you signed off on it, we're good and it's solved. On the other side of it, we will have others who will say, because we went through this review, you get a smaller margin for error. And we know that the margin for error is significant out there. There's a study out there, and here's a quotation out of it. If you've not read this study, I think it's really valuable. It's really a good resource tool for you. This was done by McGraw-Hill and the AIA Large Firm Roundtable. The title of this report is Managing Uncertainty and Expectations in Building, Design, and Construction. Could there be anything that's more on point for this discussion we're having today in terms of pre-construction services and how that moves things? What that said is that the average impact of design imperfection cited by owners is typically in the range of 3 to 5% of construction costs. What that means to me is if we go back to that standard of care clause and we look at what's going on out there, that means that under the normal, reasonably careful standard of care, even as acknowledged by owners under this, and knowing that it's not perfection, they should at a minimum be allowing a 3 to 5% contingency to cover unforeseen conditions, changes in the design, RFIs, change orders, schedule issues arising out of those issues, so that they have that there. Long way of saying that should not be your professional or financial responsibility that's out there. Now, that is theoretically and technically in the ordinary circumstance, the ordinary project. So if we go back, remember, we have this slide here from the Kentucky Transportation Cabinet, which says that gets reduced by 1.5%. So in that world, what does that mean when we look at a clause like this or a standard like this that says typically it would be 3 to 5%? Does that mean the 3% gets cut in half? Where does it go from that perspective? I've had arguments all over the map on this, all the way down to the argument that if you go down a thorough constructability and a peer review process, the expected contingency for design changes should go to 0. I've literally had experts say that. I've had architects, experts on the other side say it. I've had public entities, private entities, all sorts of people take that position that if we are going to invest this up front, we should be eliminating this imperfection, and anything that remains does go to the design professional. Well, obviously that gets very complicated. I don't think that's a realistic worldview, but that's one of the claims that's out there that we face and we confront now as we go forward into this arena that's out there. So it then gets to the who. So I'm kind of moving back and forth, obviously, between the peer review and the constructability review. Remember, on that Florida International University bridge collapse, one of the findings by the National Transportation Safety Board was that it was an inadequate peer review. This was the headline. This was the headline splayed all over the newspapers, the engineering news articles, the local media, all sorts of things, that finally in January of this year, that peer reviewer settled that case. So after 2 years of litigation, the 6 families, there were 6 people killed, and finally they resolved the claims against the peer reviewer 8 weeks before they were supposed to go to trial, understanding that before that, the families had already been paid $103 million by the original contractor, by the original design firm, by other parties to it, and this was on top of it. The settlement's technically confidential, but let me assure you, it was significant for that peer reviewer. It was significant for them monetarily. It was significant for them because they spent 2 years embroiled in litigation with that distraction and that loss of time. And then it was very significant for them and their insurance company because they had the findings against them that they had to deal with, and they settled for a very, very significant amount of money in terms of what took place there on that particular project. So all of that would kind of indicate that thorough and good peer review is going to bring down cost and change projects, and people are wading their way into it. I'm going to just share one of the projects currently on my desk, which kind of gives an example of be careful what you ask for, be careful how you structure it, because it can dramatically change things. I'm working right now on a major airport renovation project and expansion. As a part of that particular project, it's a design build agreement based on established owner criteria. As we got partway into the project, the owner decided that they thought peer review was important, particularly with respect to the engineering field involved. And so they introduced a seismic peer review panel, and they did so at about the 30% construction stage. They brought in a team of no less than 4 seismic peer reviewers to take a look at it. It's a public project. I understand it. I understand the issues that took place down in Florida. I understand the issues that have taken place in other parts in the country with respect to significant infrastructure projects. So this seemed like a good idea. But that peer review panel came in and essentially supplanted, enhanced, and ramped up the original owner published criteria for the project, and they did it at the 30% construction document stage. The result of that was that just for one element of the project, there was a $14 million cost quantity growth for additional steel, rebar, glass, earthwork, etc., and a 195-day delay as they went through incorporating these new standards, having them again reviewed by the peer review panel, and going through that entire process that's out there. So understanding what the process is, the timing, and all of those issues is very, very important to what all takes place here. I know about this one because nobody wants to pay the $14 million, and it's very much disputed who is going to pay for and be responsible for and get compensated or not compensated for a 195-day delay on that particular project that we have. So as I said, as a roadmap for where we want to go into this, I want to give you an overall model, an approach that I think works for the peer review side, that works for the constructability or cost or other early review by non-design professionals, and the other variations on the theme that could fit under that IPD light standard or that genre that we're talking about. So the first one is objectives. What are the objectives that are out there? What should we have in terms of how we manage that, in terms of managing what's taking place? What is our purpose in doing it? As I just laid out in the current one that I'm dealing with, I think they thought maybe safety, maybe cost, maybe just a good design review, but they just kind of threw this panel at this project without really refining it in terms of what's taking place. There actually should be another bullet point there between objectives and timing, because those are separate issues here. Separate note, this PowerPoint is available. PUA can provide it. There'll also be some other resources at the end we'll identify, and those resources are available to you, and absolutely PUA can get you copies of all of those. But timing is also important. Timing in terms of when we get into it, how many times we do it, and what's the result. The scope and the standards then are the other critical issues. What's going to be the scope of the review? What are we looking at? And what are the standards we are going to be measuring it against, so that it either becomes limited, all-encompassing, or something in between, and that everybody involved in that process really understands what we're doing, how we're doing it, and what we're going to get out of it. We then get into the process. And the process is incredibly important for how we manage these types of things. As I referenced earlier, I was involved recently in this large public infrastructure project in terms of what took place and what they had going on in that particular project. In that situation, they had no less than 4 separate pre-construction reviews of one form or another taking place simultaneously. They had a peer review of elements of the projects by other design professionals. They had a construction manager review of the overall project on some criteria that I'm still not sure of. They had a cost review underway by a cost estimator, and they had a constructability review ongoing by a contractor, all going on simultaneously, all uncoordinated, with inconsistent documentation in terms of what's taking place. The thing that is most important, the thing that is absolutely critical for design professionals coming out of this, is resolution and closure. On so many levels, in a pre-construction services kind of serves as what I'll call an issue spotting exercise, where issues are identified, people raise concerns, they say the what ifs or what abouts, which puts these issues up on a board. And the problem is, if those issues are not resolved and closed or somehow taken care of, and they become later an issue, it becomes a notice issue with an easy point of criticism. I will tell you that for people involved as a peer reviewer, for people involved as a design professional being reviewed by a peer review or a constructability review, this is the single greatest point of exposure. Those issues that are identified, but not resolved, dismissed, or otherwise handled. And then finally, there's the point of accountability. There is the point of accountability, obviously, for the design professional who is still going to be the architect or engineer of record. They are front and center for what's taking place, and they've obviously got their issues. How does that get changed or modified by all of this? We'll talk about that. But it's the other 2 perspectives on accountability that becomes really important. As a peer reviewer, what is your responsibility? What is your accountability? And who is that to? I want to argue that that should be fairly limited and contained, and we want to manage that piece of it because I think we can manage it for the collective good of the design community. On the flip side of it, we have these others who get involved. The cost estimators, the constructors doing constructability reviews, the schedulers taking a look at it, or various versions of those. All of those are technically, for the most part, non-design issues, and they weigh in, they raise issues, they have all of that, but almost invariably they then deny accountability for that. I believe there should be accountability for it. Typically they have some incentive by it. They're either getting paid or they have an incentive for a leg up to get into the project. There's an incentive for them to do it, and with that incentive, with that consideration, I believe should come accountability in terms of what's taking place there, in terms of what happens. So that's the overall model. Those 7 steps that we have there, with timing correctly punctuated there, the 7 things that if you're sitting down and looking at a peer review project, in a pre-construction service contract where others are going to be involved, or some variation on the theme, this is my starting point checklist based on experiences. And I sit down and work through these issues with clients about where we should go with all of that. So let's start and kind of work our way through it. The first part is to really try to be aware of the objective. Client expectations, contractor expectations, other expectations coming out of any process is so critical and so important. And what I would submit to you is that so often the buzz around this, much like we've had the buzz around BIM and IPD and some of those other things, is so significant that people hear all of the positive buzz without thinking through the ramifications on the project in terms of other expenses, other realities, and the limitations on the process. These are just kind of two quotes that I pulled out of the media from recent years out there about these processes in terms of what's taking place, so we can understand what the buzz is and where it's there. The New Jersey Law Journal, in terms of an article on this process, had this quote: peer review provides confirmation and assurance that the design is sound and that the design specifications are clear. Confirmation and assurance. Well, assurance gets into the neighborhood of guarantee or warranty of perfection, and that starts to make me a little nervous, but that's out there as the standards that are out there. The confirmation, the clarity, I don't really have an issue with those. We'll talk about those a little bit as we go on, but it is those stronger words of assurance that take place. In an article out of the World Conference on Transport Research Society, they characterize constructability review, which can mean so many different things, as being a process used during project design to infuse construction knowledge into the design process. To infuse construction knowledge into the design process. That sounds really good. But what does it really mean, and what are we seeking to realize or come out the other side of that with as we get deeper into it? With that, I believe that we need to be clear about the objectives. I think you need to be clear about it in your scope of work and your communications with your clients, because otherwise this will burden what's going on. I believe that those communicated objectives need to be defined and realistic, and they need to be limited. To that end, I'm going to offer up this clause, and this clause really could drive the rest of our program. If you take nothing away as kind of a roadmap for how to handle it, this one paragraph really captures so much of what we are trying to do. In the first sentence, we're really trying to identify what's taking place. First of all, it's the client that chose to do it, right? This is a client-driven decision. It's not generally driven by the contractors or the design team. It is generally client-driven. And it is in order to pursue specific, limited, and focused pre-construction activities. So there we've just put a framework around it, right? It is supposed to be specific. It's not all encompassing, it's limited, and it's focused. And then we have, in order to confirm and validate elements of the project program and plan as set forth below. So a couple things there. First of all, we're not assuring, we're not guaranteeing, we are confirming and validating the elements. And then we want to make sure that we list those elements below. What are we really trying to do? And make it a list that is all-inclusive, meaning it is a list, will cover the following, and then we disclaim anything else coming out of it. Going to our second paragraph or sentence here, the colored in blue, what we're doing is we're trying to confirm the reality here. The client recognizes that design and construction remains a dynamic and evolving process, and that different parties may have different opinions or positions. I think those are true statements. Those are reality checks. Those are reality expectations. And I think it is so important to have that. So many clients go into the pre-construction thing and they believe that then they go out to bid and it's a set it and forget it moment, regardless of whether or not it's design build or design bid build or something in between. And I think this establishes the appropriate expectations around it. And then we need to make very clear, if you didn't understand the blue sentence, we have the red sentence, which is, unless expressly agreed otherwise, such pre-construction services are not a warranty or guarantee of cost, schedule, or any other issue. Remember that clause that we have out of the standard jury instructions, the one that says we are not negligent just because it doesn't work. This takes us back to this. This is a sentence that I will oftentimes add to your standard of care clause. I would add it in, and you'd have your standard of care clause in your agreement, much as you would as a good PUA member, or as you have otherwise from using the AIA documents. And I will add in or look for the enhancement that such standard of care is not a warranty or guarantee, and you as the design professional have no such obligations for what is out there. And then we get to the final sentence. And I think this is the kicker, and this is the one that goes to that closure and resolution moment that we talked about. And it says, in the event of differing positions, client shall have the final authority to direct or authorize an action. This goes again to recognizing whose project is it? It's the client's project, and they are the ones who should be in the position of making those final decisions. We can lobby, we can weigh in, we can make recommendations, but it is their project and their direction. This kind of goes back for me about 10 years. About 10 years ago, I was commissioned by the AIA Trust to write a white paper on what were then the evolving issues of sustainable design, BIM, and new technology and products. And I wrote what I thought was a very good white paper. The AIA then came back to me and said, we want you to add a new first chapter to this, a new first section to this, which talks about informed consent and what it means for the client to buy in and sign off on this. And it made perfect sense, didn't it? It made perfect sense because it's the client's project. And just as sustainability and BIM and new technology are issues which should be the client's choice and selection, so these issues with pre-construction services, these issues with peer review, ultimately the decision maker, the authority, the one to make the decision should be the client. And if we have them do that, and if we have that and document that appropriately as we go through the project, we're going to close the issues, we can go forward, and theoretically as design professionals have the confidence that we're not going to be responsible for anything that goes awry in the project as we go through that particular element of what's out there. The second major building block, or the third major building block that we have here, I think, no, second one here, is timing. When are you going to do this? And my experience is that this runs the spectrum. I have seen everything from being in at the very beginning of a project before we even get into design, where it's a part of programming. There are a number of periodicals and articles out there that espouse that position, all the way through to the other end where it's kind of the final check, the check done just before a set of plans goes in for permit and approval. And I can make arguments around all of that and how that should take place. The key is that it should be established, and it should be established up front. As a potential menu for you, I would suggest that you take a look at something like the AIA B101 and the elements that you would have there, from schematic programming and schematic and design development through construction documents, the various iterations, all the way up to permitting. And you can pick what's there. What we need to do, though, is we need to recognize that any such review at any milestone is going to have schedule impacts. And we need to build that into the process. We need to recognize that there is a sequence that drives that schedule impact. As a design professional, you're going to deliver your design and make it accessible to somebody to look at. A peer reviewer, a contractor doing a constructability review, what have you. They're going to take that element, they're going to look at it, give you feedback, and then you need to look at it, take your action, maybe meet and confer on it, go through that process, and you need to build that time into what you're doing. In that, I'm just going to say again, it is so important to have a quarterback, a coach, a clerk of the works, somebody who is in control of that process with the capacity to monitor and make sure that it gets done, with the capacity to make sure that it's going forward. I am going to suggest that if you're the design professional of record, that generally should not be you. It can be you, and you should be holding other people accountable. But because theoretically, so many of the definitions of what we're going to see call for these constructability or contractor reviews or the peer reviews to be, quote, independent, I think taking a look at something else that you have out there is really important for how we do that. And so I think we need to have a manager or a controller on that, as opposed to too many cooks in the kitchen, too many things that are going on. The other thing is, if you're going to have this as a part of your project and you are the design professional of record, in addition to building it into your schedule, please build it into your cost and fee. These processes, well, I think they can make your design better, also can add to the fee and cost for your schedule. And it's going to be dependent upon what you have coming out of it. And if you don't build it in up front, it's a great challenge to get it paid for later as an additional service. It's hard to get paid for later as an additional service because what the owner or the client's going to say is, you're only having to do this because somebody else had a question or an issue with your design. And so I think you need to make sure you build it in up front in terms of the timing, the schedule impacts, and the scope and fee, and have it established when this is going to take place during the course of your project. The next big category is out there is, what are we looking at? What are we trying to accomplish here in terms of what's taking place? And I think there are really two categories here. There are the basics, which I have on the left, and the alternates, which I have on the right. And I want to distinguish those. The ones that I have is the basics. If we're going to look at most of the definitions of what a constructability review is going to look at, it's going to have those elements over on the left. Code, is it code compliant? Is it clear? Does it convey what is out there? Are there conflicts here where things simply can't be built together? Is it safe? And is it constructible? So those are the things that we generally are going to look at in terms of what's there. Might be all of them, might be some of them, might be targeted at various points in time. It may also involve cost. But as you'll see, I'm very cautious about using cost as a part of the basic elements because we get into the alternates onto the right. Remember, the standard of care is a band of acceptable discretionary design practices that can take place, and it all can be within the standard of care. I think arguably all of the things on the left in terms of what's in that list are basics, and those would be inevitably required by the standard of care, that we have those things covered. On the right, we have the alternates. The first one going to cost issue. I have in quotes, value engineering. If you've ever heard me talk before, you know I believe that's one of the great oxymorons in our industry. Enhancements, where people are looking and saying, what can we do better? What can we do different? And those discretionary inputs. Where I can, I want to eliminate those as a part of the constructability pre-construction reviews that are out there, because I think they complicate the design process. There is one architect of record. There should be one engineer of record for each discipline. They are in charge and responsible for those parts of things and things that are out there. If the owner wants to get into these other issues, I think that needs to be scoped very differently. And I would absolutely make this part of the additional services component that you have out there. I think you also need to establish the process. The process can be established upfront by contract. It can be established after the contract by an agreed memo and protocol in terms of what's going on. This is my checklist for what I want to make sure that I've got in my process. And we've talked about a number of these issues already. We're going to talk about them more in terms of what's taking place, but as a checklist for a process and how we're going to manage peer review, how we're going to manage constructability reviews, code reviews, any of those things that we have out there. This is my checklist for managing how we are going to do it and who is going to be responsible for those particular issues. If you have others that you think should be about part of the process, I'd love to hear about it in the chat room and have you introduce that for what's going on that's out there. Resolution and closure. As I've said, with respect to the peer review process, with respect to the constructability review process, resolution and closure is the single greatest issue and exposure for what design professionals have out there, and we need to solve that issue. I'm going to give you an example that we're going to come to in a little bit, but what I've had is probably 5 cases on my desk going to litigation in the last 5 years where the sole issue are the open or unresolved issues at the end of a constructability review or a peer review process, and those are then somehow linked back to the issues in the litigation. Open issues are the bane of our existence, and we need to manage that. We're going to talk about that in a little bit, how to do that. Disagreements as we've talked about, are really problematic. If you remember that earlier clause that we have, there are going to be differing opinions. There could be differing opinions between the peer review professionals, there could be differing opinions with the contractors. As we've talked about, sometimes the peer reviewer is going to come in, and there's articles out there that will speak to the fact that they come in with a bias. They're trying to impress the owner by finding those things that they can find with your services to make them look better and to put them in position to get the next project. So not always realistic, not always within the standard of care. How do those get resolved? How do we resolve those disagreements? We need to get direction and resolution. We need to have a path towards accomplishing that. And here are two kind of approaches. These are different approaches at the different ends of the spectrum as we have it there. But what we have here is we have the express version where the client is being obligated to provide the direction for what is going on. And so we're saying we're going to raise the issue. They will be advised of it, and it says that they will make directions or provide authorization on issues identified by such reports. And that we then, as the architect or engineer of record, the peer reviewer, the contractor, may rely on that direction, and we are not going to have accountability for any issue which might have been resolved differently or dealt with by that action. So it's essentially putting the owner on notice up front that they're going to be responsible to make those decisions. The other version of it is we can have a default provision. I don't like this as much because it's not as clean as it closed, but what it says is we're going to keep you involved in the process, we're going to keep you informed of the process, and where there are disagreements, where there is no action taken on it, that we will proceed and go with it with the assumption that they've agreed, except where the client disagrees or directs otherwise in writing. At least we have covered that potentiality and we've gotten down that path and we can manage it in terms of what's taking place. What we don't want to get caught up in is a situation where it's unresolved. This is an exemplar of the top part of a spreadsheet that I've used, that I've seen used in terms of how to resolve this. And so what we have here is we have an example of a peer review check sheet report, a constructability report kind of on steroids. And what we would have in the left column is identification of the issue. Then we're going to have in the two columns, might be three columns, what the positions are competing on the issue. Is this adequate? Is it not adequate? What should be changed? Why should it be changed? And then we're going to have a client direction and a client signature, a means to holding the client accountable for what's taking place in terms of what's out there. What I will tell you is that so many times I've gone forward in projects and I've had major litigation because we did not have that. I had something, in fact, on a recent project, which was not very dissimilar to this. It had a position for the constructability review to identify the topic, the contractor's comment, the design team's response, and then an open column for resolution. In that situation, about 97% of the issues got resolved. About 3% weren't resolved. They were left blank on the final version of that form because they were working through it, and then they said, we just have to get under construction, and they got going. Well, as you can guess, because I know about it, some of those issues came back to haunt them. And when those blank issues were raised with my architect in deposition, his response was, well, I guess we just agreed to disagree. That didn't solve it. That led to the litigation, that led to the claims, and made us incredibly vulnerable because the issue was expressly called out there and was there for people to point to and seize upon as an architectural point of exposure and responsibility that's out there. Accountability is this kind of final issue that we've talked about, and we're going to go through them each in a moment as we walk through the two sides of this equation, the peer review side of the equation and the constructability and cost side of the equation. But I think we need to look at them differently. In the peer review situation, it's a fairly simple spreadsheet. The prime consultant and the prime consultant's design team are kind of on one side, what's their accountability, and what is the accountability and responsibility of the other peer reviewer who is giving them input into that. What I think always goes lacking in these agreements, which needs to be addressed and identified either in the agreements or in the protocol or in the documentation, three ways to slice that, is what's the client's accountability? What's the client's responsibility in that? If they make an enhancement change based on the peer review, if they decide an issue that's out there by the peer reviewer in terms of what's taking place, how do we manage that? On the constructability and cost side of it, that's where we're having the contractor come in, and it's going to depend a lot on who that reviewer is. Are they the contractor who's ultimately going to do the project? Are they the construction manager who's ultimately going to manage the project? It astounds, frustrates, and agitates me how often we have contractors and construction managers involved in pre-construction services who are then awarded the project and involved in the project, who basically treat the pre-construction services as if they never existed. I don't think that's right. I think they need to be accountable in that project. We then have the other version of it, which is the advisory reviewer, which in my experience is far less frequent, doesn't happen quite as often. We then have the AE team. What's our role? What's our accountability in that process, particularly with respect to open or unresolved issues? And again, where is the client? I have the client in red under both sides of this, because to me, they are the one whose role, accountability, and ultimate control and direction, because it's their project, is so often overlooked, unresolved, and undocumented in these situations. And I think it's absolutely critical and imperative that we do that. Sorry. Remember what we have in terms of a standard of care. Remember, we had the one that said that we do not guarantee in the jury instruction in California. This again is the perspective that's out there, the tag onto that, which is the architect and engineer is negligent only if we are not as skillful, knowledgeable, or careful as another reasonable architect, engineer, geotechnical engineer, landscape architect, surveyor, whatever, would have been in similar circumstances. And that's why so often I have embraced, and we've made great benefit and use out of having a peer review, because we can go to that and say, look, here's the standard. What would somebody else have done under the circumstances? These people actually reviewed our plans, they reviewed our specifications, they reviewed our report, and they signed off on it as passing their standards. There's no better defense for what's out there. The problem is that does not always happen for us, and it's the other scenarios that can lead to the great pressure that's out there. And as a result, there's growing peer review pressure for the peer review imperative. As I've said before, it's mostly in engineering. Structural engineering has been at the head of the class for this, not architecture. However, that is dramatically evolving for public projects of all disciplines. I believe it's also dramatically involving with respect to areas such as code compliance and waterproofing, because in those arenas, water penetration, water intrusion claims drive so many claims dollars, drive so many issues that it's out there and it's taking place. So it's also now being recognized internally. I'd say about 5% of the contracts or projects I consult on for the contracts now have an internal QA/QC procedure where the design firms are on their own going out and engaging a third-party reviewer on a focused basis. Might be for waterproofing, might be for code compliance, might be for another discrete issue that's out there. As a sign of how the imperative for peer review is growing, we now have mandates, statutory mandates in New York, Florida, and California to mandate peer reviews for structural engineering and geotechnical engineering on specific types of projects. I only see this growing over time. I think we are going to start to see these issues with respect to mechanical issues as we go forward, particularly coming out of the recent phenomenons and building issues we've had in the coronavirus time period. I think we may also start to see them in the future with respect to these water intrusion issues that are out there, but it's absolutely becoming part of what's out there. Your own associations are also heavily advocating for it. This is the American Society of Civil Engineers. And what they have done here is their statement 351 has put out a statement where they are supporting the use of peer review for projects. They're calling for it. I like it. I think what they say is absolutely true, that it is going to increase the quality of the projects. I think it's going to enhance what's going on out there. And honestly, I think it's going to help our practice the more we can engage and promote this. Remember, the standard of care is what others would be doing under similar circumstances. In that scenario, one of the best ways to learn what other people are doing to stay consistent with standards, in addition to coming to programs like this, to attending conferences, is to actually see what other people are doing on projects. And peer review services is a great opportunity for that. So getting somebody in to look at your review, I think makes sense. Even more so, seeking those peer review opportunities that are out there is really important. The problem is, how do you get into that? Where's your responsibility around this? Because as a peer reviewer, there is incredible liability exposure because you've just provided professional services looking at a huge design potentially, but not responsible or into all of the details, sometimes accepting things as true and where it went. We saw the scenario that happened with respect to the bridge collapse. That's not an isolated circumstance. And we've seen this many times that are coming out of that. For that reason, the National Society of Professional Engineers actually has this model statute, this model legislation that they have put out now, that they endorse or advocate, this first paragraph here, that third-party peer reviewers should be immune from civil liability as long as they act in good faith and have no other role in the project. So that independent peer review can take place, but it should be given immunity. Unfortunately, this hasn't picked up in most states except in an emergency consequence. Kansas and Missouri are the only two that I'm aware of that have this kind of on a comprehensive peer review basis. If you're aware of others, I would love to hear about them either by email or in the chat room, just to update that part of it. Let us know what's going on out there in terms of what's taking place. So in terms of how to manage this, we need to avoid the common perils. This is a standard kind of snapshot of what so many of my peer review processes look like. It is a list of issues where they identify where they got the reference, what their comment is, and what the resolution is on the right side. The problem is that the resolution on the right side, if it's not to agree or it's left blank, leads to an open issue. We don't agree means that you have a difference of opinion that could lead to a problem down the road. Even worse is the blank one that's there. So there needs to be an intentional commitment and follow through to closing this out. I'm also going to recognize that in doing that, so often we're not going to get to closure. We're not going to get to where we go. And so I want to give you this template of a checklist or a process if you're the architect or engineer of record with a third-party reviewer, what to go through. The first question is, do you even want to make a list like this? And I'm going to recognize that in today's world and the common practice is to do a list like this. In the quote old days, and I'm old enough to know what the old days were, we'd sit around a table, we might redline the documents, we'd talk them through, and we would come to agreement. I think a good, effective, collaborative process. But in the days of technology, remote operations, different locations, the list seems to be the prevailing pattern. Whether it is in this peer review concept or in the constructability review, I think it is really important to reject or exclude the extraneous. That architect I spoke of earlier who said we agreed to disagree, his comment was a lot of that, it wasn't really architecture, it was means, it was methods, it was scheduling, it was sequencing. Then say it. Instead, they left it blank, it became an open issue and it was there. Respond, resolve, and close the issues wherever you possibly can. Respond, resolve, and close, and put that into the documentation how you've done it, or if you think it's irrelevant. When you go through and you do that, one of the final and great things to do, where you have those open issues, where you have those disagreements, where you come to a different path, try to secure at the end the confirmation and sign off of the peer reviewer. That is, we've been through this process, we have sat and gone over the documents, we've exchanged back and forth the list, we've exchanged the red lines, whatever we've done. And as a result of that process, you are satisfied that our design is consistent with codes and the appropriate professional standard of care. If I can get that sign off as the architect of record, first of all, you're not going to have to come see me, but if you ever have to come see me as the attorney, what a great gift to defeating the claims that we have out there. The greater danger, I think, is that peer reviewer. That peer reviewer, as we've talked about, is so perilously situated that they paid out huge amounts of money down in Florida. The NSPE has advocated for this immunity statute. And so I think that we need to do something like this to be very clear about what our scope is so that we do not become a second pocket, a second point of going on. And I think it's important to make everybody understand the relationship. The first sentence I've got here for you is an exemplar, not too dissimilar from what you would have on, I'm sure, your shop drawing stamp, your submittal stamp or something else. General conformance for what's out there and what we are looking for. Codes and other identified regulations, internal conflicts, omissions of necessity or necessary information, and safety. Where an issue is identified, we are not going to provide the solution. And that's really important. Just as I would advocate if you're doing CA, not to tell people how to fix a safety condition, you identify the issue and not the other thing that's out there in terms of what's taking place, because that is ultimately the responsibility of the architect or engineer of record that is out there. I think this statement, this qualification is really important. And then I think that we need to be clear about the beneficiaries of this. We can do it for an in-house firm, we can do it for an outside firm, we can deal with it in multiple ways, but to be clear that our intended beneficiaries are our client, and it is not intended for third-party benefits or causes of action. Contractors are not supposed to get the benefit of our peer review, even the designer. And then we have there at the bottom a possible follow-on question for confidentiality. If you're doing it for the design firm only, it should be limited and contained on that context. And then I think the limitations of liability is so important. To limit the liability to third parties, to limit it to our sole negligence as we have here, and then possibly to have a dollar amount on any limitation of liability. Because as the peer reviewer, we're not getting a full fee, we're getting a limited fee. We should not have an open-ended liability exposure that's out there. We can have a debate back and forth whether or not we should have an indemnity obligation to our defense or benefit here from the architect or engineer of record. I'm going to generally say that I don't think that's necessary or appropriate because I work on both sides of that equation, but it's something for you to consider out there. I want to close by talking for a moment about the constructability review and just the real world perspective. This case has dominated about the last 3 years of my life. In this situation, we had a public entity that was using pre-construction services for the first time. In doing that, they had simultaneous review going on by a construction manager, a peer reviewer, the permitting agency, and by the contractor. And the contractor was handsomely compensated at approximately 5% of the anticipated construction cost for the project. That's a bit of a head scratcher. If we take the Kentucky study, that would have said they were going to save 1.25%, but they spent 5% on it. They went through the process. This was, again, one of my poster children for what happens here. 95% of the issues were resolved. 5% were left blank, unresolved, or agree to disagree, with about 12,000 RFIs then coming up during the course of construction. It's dominated my life for the last 3 years because of those 1,200 RFIs and the lack of accountability around all of that. So our imperatives here is, again, consistent with that model we gave you at the beginning. The scope and standards, what are we doing? To have a manager coordinating. If there's multiple reviews taking place simultaneously, to have a manager overseeing that. How are we going to document it? What's the closure? And so important for the design professionals, what is the accountability for the other participants in that process? They should not get a free pass on it. They should be accountable for what they've done, and especially so if they're going to be involved in the project ultimately down the road. To that end, this is the accountability clause that I believe that we should put into it. That is, they are the CM, the contractor, the CM, whoever's doing it shall remain solely responsible for all cost, schedule, and sequence and safety issues. Just because they raise an extraneous issue like that in review does not make us responsible for it. Became our inbox. And then when they identify an issue, whether it's resolved, unresolved, or however it goes in, they are going to build it into their price, their project model, and the final part here, really important, and shall not be entitled to any additional compensation or schedule adjustment for this issue. They knew about it, they saw it, they commented on, that is then their responsibility for what they are doing. As I mentioned at the beginning, the PowerPoint is available. Just make a request in response to PUA in terms of what you have. We can get you a copy of the PowerPoint. These other resources are available. There's a white paper that goes along with this on this very topic. Other topics that we've written on that are available for you would be on the agreements, limiting your liability and managing these precarious contract clauses. Please reach out to your PUA representative. Please reach out to your broker. They can get it through PUA if you would like to do it that way. Or as always, you can reach out to me. Here's my contact information. Would love to hear from you about what's taking place in your world, what your thoughts or comments are on that. And I'm going to take just a moment and look at the Q&A in the chat to see if we have anything to resolve. And we will get out of that. And I think that we are good to go. It's very positive. The one question that did come up is this available on a recording? Yes, it is. I know that I sometimes talk quickly, and I apologize for that, but we had a lot of information to cover. I'm going to thank everybody for the kind comments in the chat. I would encourage you again, reach out to PUA. I think there are going to be some further opportunities for me to join you on these things. If you have topics that you'd like to see in the future, please let us know. And again, thank you everyone for being here.